Imagine spending, well, hundreds of thousands of rands on a highly complex commercial lawsuit. You endure months of litigation, and you ultimately lose.
Right. It happens all the time.
And then, when you attempt to take the matter to a higher court, the judge essentially looks at your application and tells you that you aren't even allowed to ask for a second opinion. I mean, today, we're looking at exactly why the legal system occasionally forces you to simply take no for an answer.
It is a harsh reality for many litigants, but, I mean, it's an absolutely necessary one for the survival of the justice system itself.
Mm-hmm.
You see, the architecture of the law requires a terminus.
A definite endpoint.
Exactly. There has to be a definitive point where the process simply concludes. A legal system cannot sustain infinite relitigation. It fundamentally demands finality. Without that finality, true justice is delayed and therefore denied for everyone else who is just waiting in line for their day in court.
Welcome to this deep dive. Today, our mission is to examine a precise, highly instructive piece of South African jurisprudence that tackles this exact tension, this balance between fairness and finality.
Indeed.
We are analyzing an April 2026 Pietermaritzburg High Court judgment. We're focusing on an analysis that's aptly titled The High Threshold for Leave to Appeal. And we'll be dissecting the strict, uncompromising parameters that govern exactly when a litigant is granted that coveted second bite at the legal apple.
And for you, the listener, understanding this barrier to entry is absolutely essential. Whether you are actively managing corporate risk, maybe observing commercial disputes, or simply curious about how the justice system protects its own limited resources.
Right, because court time is incredibly expensive.
It is. And this threshold is the primary mechanism preventing the courts from being completely paralyzed by endless draining legal battles. It filters out the noise.
So, if this barrier is intentionally set incredibly high, we really have to look at what happens when someone actually tries and fails to clear it. To understand the standard for appealing a judgment, we first need to establish the facts of the matter that was being appealed in the first place.
Yes, the factual foundation is critical here.
And the foundation of this specific legal analysis begins with a rather contentious and ultimately rejected subpoena.
We have to trace the factual genesis to really understand the court's stance. So the matter involves a corporate entity named Solbeth Security Protection Services, CC. Solbeth was entangled in a much broader underlying dispute with the eThekwini municipality.
This was regarding alleged outstanding payments for security services, correct?
That's right. Now, in the course of pursuing this municipal dispute, Solbeth took a rather aggressive procedural step. They issued a subpoena against the Auditor-General of South Africa, an institution we will just refer to as the AGSA for brevity.
Right. And the stated objective of the subpoena was to legally compel the AGSA to hand over specific documents and information. But, and this is a massive but, the Pietermaritzburg High Court stepped in and set the subpoena aside entirely. They formally classified it as an abuse of process.
Which is a very severe classification in South African law.
It really is. And the central reason for that severity was that Solbeth had already been explicitly informed in writing that the requested information either did not exist or was simply not in the possession of the Auditor General.
And you see, this immediately raises the question of motive. Why would a legal team issue a subpoena for documents they already know do not exist?
Yeah, it doesn't make any logical sense.
Well, it often points to a fishing expedition, or perhaps a stalling tactic,
Yeah.
or an attempt to artificially apply pressure by dragging a vital state organ into a private commercial dispute.
To use them as leverage, essentially.
Exactly. The court recognized this and determined the subpoena was not issued for a bona fide lawful purpose.
Right.
So, following that decisive defeat, Solbeth initiated the process we are actually examining today. They sought formal leave to appeal the decision.
And spoiler alert for the listener, that application was entirely dismissed, and it was dismissed with costs. Okay, let's unpack this. Trying to legally compel a state institution to hand over documents that you already know they don't possess, I mean, it's essentially akin to demanding a receipt from a retail shop you never even visited.
That's a perfect way to put it.
The endeavor is fundamentally flawed from its inception. It lacks basic logical merit before the paperwork even reaches a judge's desk.
And not only did they ask for the receipt, to use your analogy, but they also tried to drag the store manager into a separate, completely unrelated lawsuit over it.
Right, exactly.
Now, the primary judgment dealt with the inherent lawfulness of the subpoena itself. But the subsequent judgment, the one regarding the leave to appeal, deals with a distinctly different point of law.
Yes, how you actually challenge a law.
Precisely. Having established that the initial case was lost because of a procedurally and factually flawed subpoena, the discussion logically progresses to how our legal framework governs the right to challenge such a loss.
Which brings us directly to the statutory framework governing appeals in South African law, and a core legal shift that really changed the landscape of litigation. The source text highlights Section 17, subsection 1, paragraph A, subparagraph I of the Superior Courts Act 10 of 2013.
A very, very important piece of legislation.
Right. This section dictates what they call the true test for leave to appeal. It establishes a critical statutory requirement. Leave to appeal is only granted if the judge is of the opinion that the appeal would have a reasonable prospect of success.
And the specific phrasing utilized by the legislature there in 2013 demands careful attention because, well, it was a deliberate intervention to protect the courts.
How so?
Well, historically, under the old Supreme Court Act, an applicant merely had to argue that another court might possibly reach a different conclusion.
Just a possibility.
Yes, and that standard of mere possibility was a remarkably low bar. I mean, it led to court rules becoming severely congested with highly speculative appeals. So the 2013 Act deliberately elevated that threshold. The standard of mere possibility is dead.
It's gone.
Completely. Today, there must be a realistic, grounded prospect that another court would come to a different conclusion. Displeasure with an outcome, no matter how profound or how expensive the loss was, it simply does not satisfy the requirements of the Act.
Here's where it gets really interesting. Moving from a possibility to a reasonable prospect sounds like a minor semantic adjustment on paper. But how does that higher burden actually filter out frivolous lawsuits in the real world? Like, how does a judge objectively measure a reasonable prospect behind closed doors?
That is the crux of the matter. It functions as a stringent, uncompromising judicial gatekeeper. You see, a possibility allows for hypothetical arguments, speculative legal theories, and incredibly remote chances.
Right. Anyone can argue a possibility.
Exactly. But by demanding a reasonable prospect, the law requires the applicant to demonstrate a grounded, evidence-based probability that the appellate court will actively interfere with the original judgment.
That's a much heavier burden.
It is. And structurally, it forces a fascinating psychological exercise upon the presiding judge. I mean, the judge who wrote the original judgment must put aside their own ego, step back, and objectively evaluate if their own reasoning contains a material flaw that a panel of appellate judges would realistically overturn.
Oh, wow. So they have to grade their own homework, but with the assumption that they might have failed.
Precisely. It forces an objective evaluation of the legal merits before massive appellate court resources are expended on a new hearing.
So if the bar is now set at this heightened standard of a reasonable prospect, we really have to look at what happens when a litigant like Solbeth actually tries to jump over it. Because looking at the text of their application, I mean, it seems they tripped over the procedural requirements before they even reached the hurdle.
They did.
The law requires utmost precision, which the judgment notes Solbeth lacked entirely.
We have to look at the procedural mechanics of an appeal to understand why they failed so spectacularly here. Before the merits were even debated, the Auditor-General raised a preliminary objection. They pointed out that Solbeth had failed to formulate concise grounds of appeal.
And there are strict rules for that.
There are. In our courts, there is a standardized playbook governing how civil cases operate, known as the Uniform Rules of Court. Specifically, Uniform Rule 49, Sub-Rule 4, dictates the exact procedural requirements for civil appeals in the High Court.
And it mandates absolute clarity.
Clarity and specificity, yes. The court found significant merit in the AGSA's complaint that Solbeth simply ignored this rule.
Yeah, the judgment specifically noted that rather than identifying precise grounds of appeals, Solbeth advanced what the court described as a broad and all-encompassing challenge to the judgment. I mean, essentially, they just stated that the judge got everything wrong.
Which is entirely insufficient. I mean, a proper application for leave to appeal requires rigorous clinical discipline. It is a surgical strike, not a shotgun blast.
Right.
The applicant must engage directly with the text of the judgment. They must identify the specific factual or legal findings being challenged. Furthermore, the applicant must clearly explain the alleged errors made by the presiding judge, and crucially, they have to show why those errors are material enough to alter the final outcome.
But wait, let me push back on that a bit. if I just lost a major commercial case and I feel the judge got it completely fundamentally wrong, isn't a broad, sweeping complaint just a natural human reaction? Like, why punish a litigant for lacking microscopic clinical precision at this early application stage before they even get an audience for the actual appeal?
I understand that perspective.
Yeah.
But while a broad challenge might be a natural emotional reaction to losing, the judicial system operates on logic, procedure, and fairness to all parties. It does not operate on the emotional catharsis of the loser.
Fair point.
The requirement for microscopic precision exists to conserve judicial resources and to ensure absolute fairness to the opposing party. Look, if you fire a metaphorical shotgun with a broad, sweeping challenge, the appellate court and the respondent, in this case the AGSA, they are forced to guess exactly what you are aiming at.
Ah, I see. They don't know what to defend against.
Exactly. Precision ensures that the appellate court knows exactly which legal mechanism it is being asked to review. And just as importantly, it ensures the respondent knows exactly what specific case they must prepare to answer. It prevents trial by ambush. It forces litigants to replace reactive dissatisfaction with rigorous legal analysis.
That makes perfect sense. The respondent cannot defend themselves against a vague feeling of injustice. They need specific legal points to argue against. But the source text indicates that even if Solbeth had managed to file a procedurally perfect application, compiling flawless, concise grounds under Rule 49, they still faced insurmountable substantive hurdles in both fact and law.
They absolutely did. We see this frequently, where the underlying foundation of the case is just weak. So let's begin with the factual roadblocks Solbeth faced. The High Court emphasized a foundational principle of appellate law, and that is, findings of fact made by a trial court will not lightly be disturbed on appeal.
Because the trial court was actually there.
Precisely. We must remember that an appellate court operates only on the written record. They do not see the witnesses testify. They do not evaluate the live evidence firsthand. Therefore, an appellate court will only interfere with a trial judge's factual findings if there has been a material misdirection, or if the conclusion reached is demonstrably and clearly wrong based on the record.
And in this particular instance, the court held that its initial assessment of the facts and its interpretation of the affidavits submitted by both parties were basically unassailable. I mean, the findings were heavily supported by the direct correspondence exchange between the parties long before the litigation even began.
The documentary evidence was remarkably clear here. The court found, as a matter of undisputed fact, that Solbeth had never been furnished with any information pursuant to the subpoena. Furthermore, the court wholly rejected Solbeth's deeply flawed legal argument that the Auditor-General, simply by engaging in basic email correspondence with Solbeth attorneys, had somehow implicitly relinquished its statutory rights and protections.
Right. Just because you reply to an email doesn't mean you waive your legal immunity.
Exactly. It's a fundamental misunderstanding of the law.
Because of that, the court concluded that Solbeth had not demonstrated that the subpoena served any legitimate forensic purpose whatsoever. There was simply no factual misdirection by the trial judge that would warrant any interference by an appeal court.
And once the factual arguments collapse, we must turn to the statutory roadblocks, specifically the alleged errors of law. And here's where we find the final nail in the coffin for this application. A central issue in the primary judgment relied heavily on Section 18, subsection 3 of the Public Audit Act.
Yes, this is a pivotal piece of South African legislation. The source explains that Section 18, subsection 3, expressly protects the Auditor-General from being compelled to disclose information relating to its audit functions in any legal proceedings to which it is not an active party.
It operates as a deliberate, powerful legislative shield. You see, the Auditor-General is a Chapter 9 institution under the South African Constitution. They are tasked with auditing the entire public sector.
A massive job.
Monumental. Now, in the leave to appeal judgment, the court noted that Solbeth had failed to engage meaningfully with this specific statutory protection in their application. And this failure critically undermined any prospects of success.
Because they just ignored the elephant in the room.
Exactly. Without a proper, legally sound argument to dismantle the statutory protection relied upon by the AGSA, there was absolutely no realistic prospect that a higher court would reach a different conclusion.
So what does this all mean? I think we can conceptualize Section 18, subsection 3 of the Public Audit Act as an absolute statutory fortress for public institutions. I mean, it is designed specifically to prevent vital state organs from being dragged into third-party commercial disputes and expending precious public resources on private litigation.
That is spot on.
Ignoring the statutory reality and failing to directly address how they plan to breach that fortress in their grounds of appeal, it doomed Solbeth's application from the very start.
That captures the systemic purpose perfectly. Look, the legislature recognized that if institutions like the AGSA could be casually subpoenaed by private vendors, every single time a municipality had a billing dispute, the AGSA would be completely paralyzed.
They'd just be in court all day.
They would spend their entire budget fighting subpoenas instead of actually auditing the country. The threshold for appeal requires an applicant to prove they have a legally sound strategy to bypass that statutory fortress. Solbeth simply ignored the fortress entirely, which is a fatal legal error.
Let's distill the core takeaways from our analysis of this judgment today. The Pietermaritzburg High Court's dismissal of Solbeth's application confirms definitively that an application for leave to appeal is not a second opportunity to re-argue your case in broader, more general terms just because you dislike the outcome.
It reinforces a stringent, necessary threshold. The law requires clear, concise, and legally sustainable grounds of appeal that directly attack the judge's reasoning.
It demands precision.
It demands proof that the alleged errors are material enough to actually change the result. Furthermore, it strongly affirms the vital statutory protections afforded to public institutions, such as the Auditor-General, particularly when private parties attempt to utilize court processes improperly to exert commercial pressure.
For you, the listener, this legal reality applies directly to any commercial or civil dispute you might observe, or perhaps even find yourself participating in. Finality in law is the default position. The burden to prove a material error and justify extending the litigation is exceptionally heavy.
Yes, it is.
Dissatisfaction with a judgment, no matter how deeply or expensively felt, simply does not equate to valid grounds for an appeal.
That is the absolute crux of the appellate system. Where an applicant cannot demonstrate a realistic, grounded prospect of success, the court is fully entitled, and indeed obligated by the Superior Courts Act, to refuse leave to appeal and bring the matter to a definitive end. In this matter, Solbeth fundamentally failed to meet that threshold on both procedural and substantive grounds, resulting in the dismissal with costs.
Which leaves us with a lingering objective question for you to ponder independently. We've established that the threshold for an appeal is intentionally set this high to protect court resources, to shield public institutions, and to prevent the abusive process.
Right.
But does this strict barrier run the risk of trapping litigants who have genuinely suffered an unjust outcome simply because they lack the highly specialized, very expensive legal acumen required to articulate the exact procedural error? We leave you to weigh the delicate balance between brutal judicial efficiency and the pursuit of absolute justice.